is reconvened. Calling case number CCV 21-0683, James versus O'Donnell, MD, for amended motion for extension of time to file notice of appeal. Appearances, please.
Good morning, Your Honor. Jared James, plaintiff.
Good morning.
Good morning, Your Honor. David Grubner and Lindsay Barrios on behalf of Nurse Takenaka, Kapiolani Medical Center for Women and Children, as well as Hawaii Pacific Health.
Good morning.
Good morning, Your Honor. Anderson Meyer on behalf of Dr. O'Donnell and Dr. Tan and Kapiolani Medical Specialists.
Good morning.
Good morning, Your Honor. Claire on behalf of Dr. Spinner.
Good morning. Okay. And we'll move on? First of all, are parties prepared to proceed?
Yes.
Yes, Your Honor.
We are. Thank you.
Then we'll move on.
Your Honor, as stated in the moving papers, plaintiff believes the excusable neglect standard for the 30-day extension of time to file the notice of appeal has been met, and therefore the motion should be granted in full. Other than that, the plaintiff stands on his moving papers unless the court has any further questions.
I don't.
Okay.
Thank you.
Thank you.
Anybody?
Yes, Your Honor. Again, our position is set forth clearly in the moving papers, but all I would say is that regardless of any issues related to timing, under controlling Hawaii authority, these orders are not appealable. These are interlocutory orders that would be appealable after a final judgment is entered at the end of the case, but not before that, so therefore the motion should be denied. Thank you.
Nothing further, Your Honor. We joined in the opposition.
All right. The court is prepared to rule. The court will take judicial notice of the records and files. Under the Hawaii Rules of Appellate Procedure Rule 4, a notice of appeal from a civil case must be filed within 30 days after entry of a judgment or appealable order. And appeals as of right may be taken from all final judgments, orders, or decrees in civil cases. That's HRS 641-1A. An interlocutory order may only be appealed as of right if the order falls under either the collateral order doctrine, allowing appeal from a conclusive order resolving a collateral issue, or the, how do you pronounce F-O-R-G-A-Y? Forgay?
I believe Forgay?
Forgay doctrine, allowing appeal from an order granting possession of real property. So that's neither here nor there here. Alternatively, a party may appeal an interlocutory order entered by a circuit court if he or she receives permission from said court. HRS 641-1B provides that upon application made within the time provided by the rules of court, an appeal in a civil matter may be allowed by a circuit court in its discretion from any interlocutory judgment, order, or decree whenever the circuit court may think the same advisable for the speedy termination of the litigation before it. Here, the orders plaintiff seeks to appeal are not final orders, as they do not resolve any claims or determine the outcome of the case, and further, plaintiff has not applied to this court for permission to appeal the orders, and of course the Forgay doctrine nor the collateral order doctrine apply. Thus, the court finds that these orders at issue are not presently appealable. Moreover, and in the alternative, upon a showing of good cause, the court may extend the time for filing a notice of appeal upon motion filed before the initial 30-day notice of appeal filing deadline. So I'm going to go through the time requirements anyways, just as an alternative basis for my ruling. If a motion for extension of time to file an appeal is made after expiration of the initial 30-day deadline, a circuit court may, upon showing of excusable neglect, grant said motion if it is filed no later than 30 days after the expiration of the initial 30-day filing deadline. However, no such extension shall exceed 30 days past the prescribed time, i.e. 30 days after the initial 30-day deadline. So in other words, the latest deadline a circuit court may grant for filing a notice of appeal is the 60 days after the entry of a judgment or appealable order. And the court cannot extend the filing deadline further, as the failure to file a timely notice of appeal in a civil matter is a jurisdictional defect that the parties cannot waive and the appellate courts cannot disregard in the exercise of judicial discretion. Kahiaku versus Child Support Enforcement Agency. Moreover, the Hawaii Supreme Court has explained that the phrase excusable neglect, as used in Rule 4A should be construed pursuant to its plain language. Neglect that is excusable, which involves a broad, equitable inquiry taking into account all relevant circumstances surrounding the party's omission. Here, the orders were entered on August 23rd. The original prescribed time period in which to file an appeal expired on September 23rd. The 30 days past extended that deadline would have expired on October 23rd. Plaintiff did file the present motion on October 22nd. However, given that he filed it the one day prior to the expiration, the maximum time period for filing a notice of appeal has already expired. Even if the court found excusable neglect existed in granting the plaintiff's motion, he still would not be able to timely file the notice of appeal for the orders entered on August 23rd, 2024. Therefore, and for both those reasons, plaintiff's amended motion for extension of time to file notice of appeal is hereby denied. Who would like to prepare the order?
Our office will prepare the order.
Thank you. Anything further? Anything further from the plaintiff?
No, Your Honor.
Nothing further, thank you, Your Honor.
In other words, Mr. James, you'll have a chance to appeal. We just haven't gotten there yet. If an appeal is, in fact, necessary at the end of all of it. Anything further?
No, Your Honor. Thank you.
Thank you. Court stands in recess.
All right. Orders in recess.